there's the burden of data governance, and that's costly as well. And having privacy enhancing technologies might have a lot of upfront costs, but it does reduce the data governance by having, aggregated and anonymized information instead of just raw text information floating around. There were ways to use, secure multi-party computation as well as homomorphic encryption to bring together different data sources to compute on a shared data set without individual parties of that computation seeing the other's inputs. I think for the implementation of pets, especially for enterprises that are ready to invest in it and have the resources to fully navigate it, it is critical for non-engineers such as regulatory teams and legal teams, especially privacy legal and IP legal, to be involved in that process and have their input.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. We have Seon Kang here today, and she is lead privacy counsel on AI governance and privacy enhancing technologies at Visa. She is fully versed in comparative privacy law across the US, the EU and the UK. She studied at Stanford University, Berkeley in the US, as well as UCL in London, and is a member of the New York Bar. With her, we're tackling a highly complex but very exciting topic: privacy-preserving machine learning, as well as a more generic understanding of privacy-enhancing technologies. I believe this is extremely relevant for all DPOs in our day and age, and I do encourage everyone to go as deep as Seon has gone to get a good grasp of the possibilities in terms of data governance and risk management. Seon, thank you for joining me.
Thank you for having me. I'm very excited to be here.
It's a pleasure. Where do we start with privacy-preserving machine learning when it comes to our space, privacy and compliance, and the role of the DPO, the privacy officer? How do you see the challenge and the opportunities?
Well, I'll start by defining what privacy enhancing technologies are. So
Great.
it's often called PETs, and
Yeah.
I think the best way to define it is it's a technical approach to implementing legal commitments to data protection. So in a data processing agreement, you have clauses that speak to data minimization, purpose specification, but often there aren't enough technical controls to supplement those promises and make sure that they're actually reflected in the systems and the products that you're working around. So there's a lot of different privacy enhancing technologies, and I'm hoping for today's session we can focus on cryptographic methods and decentralized methods. But they're very prevalent because there's a growing need for data analytics. And at this stage, we know that data can do a lot of good if you use it in the correct oversight with the correct governance mechanisms. However, having more data is a risk and it's a liability. And I'm sure anyone who is in a privacy governance or a privacy legal team understands that. So having a technical infrastructure that protects data by default, it's significant and it's an enabler into utilizing more data with safer guardrails.
I agree, and it's a great intro. Thank you. So, if we look at decentralization, starting with the second sort of block, so decentralized methods, Are you looking into any decentralized technologies? What's your view in that space?
Yeah, so when I started my career in tech law, I started as privacy counsel who's focused on the partnership of law and technology for sustainable innovation. So I actually started off in the consumer protection space with the Electronic Privacy Information Center, where we were making a lot of high-level principled recommendations on using less data. But as I began to work with technologists in my time at Stanford and in my time at startups, I realized that if you use more data, you can make better models, and there's a lot of good data for purpose initiatives. So the question was, how do we do that? And the answer really was in privacy enhancing technologies. So I used to work at a cryptographic secure multi-party computation company. We did a lot of educating policymakers and engaging in stakeholder meetings about privacy enhancing technologies and how they can be applied. And the first thing that we did really was to explain, what is differential privacy, what's federated learning, what's homomorphic encryption, and secure MPC to policymakers, most of whom hadn't heard of these techniques before, and trying to resonate into how that's relevant for some of the industries that they're regulating. And especially in financial services, privacy enhancing technologies has grown a lot in proof of concept and how willing enterprises have become into experimenting with it. So the first thing is that, these techniques, they're scary to someone who's not a technologist because it's complicated. So just to define, let's say, for example, federated learning, it's a collaborative machine learning technique via a trusted server. And I think when a lawyer hears that, it doesn't exactly illustrate into a picture, into a contract or a regulation, but and essentially what it means is it's a server that is the trusted central node of processing data, and it initiates the model and the training, and each device they locally train and only send updated parameters to the global model for aggregation. So, for example, when your phone sends a device update to your mobile carrier, it's using this method because you're not communicating your phone's updates to everybody else's phones who are on the Verizon network. You're only sending it to the central server so that they can make the necessary adjustments to optimize your services. So those are the type of methods. And it also applies to financial services because there's a lot of potential for decentralized analytics and anti-money laundering and combating financial crimes. So, for example, the UK Financial Conduct Authority did a sandbox where they gave technologists a problem set, such as how do you catch financial criminals within a network of financial institutions who, just by the design of data protection law and financial services laws, they can't freely share this information with each other, yet financial criminals operate in a very networked capacity. And there were ways to use, secure multi-party computation as well as homomorphic encryption to bring together different data sources to compute on a shared data set without individual parties of that computation seeing the other's inputs. So you only outputs and you see the networked activity, and you can work together to come up with typologies of crime and understand how proceeds of crime are moving across different networks, but you're not seeing each other's individual transaction data, which has really sensitive commercial implications.
Is there a place where, as a privacy professional or as a lawyer, you have a relevant input on which pet to choose? Do you see yourself adding that input, or are you more of a passive observer that looks at what's being chosen by the technologists or by engineers, and then you work with it?
That's a great question. I think for the implementation of pets, especially for enterprises that are ready to invest in it and have the resources to fully navigate it, it is critical for non-engineers, such as regulatory teams and legal teams, especially privacy legal and IP legal, to be involved in that process and have their input. And the reason being that there's many different drivers and motivations for using this technology. And part of it is just limitations around contractual rights to use data. And that's where the technology aspect comes in, is that, you have data that you want to use, but you might have a DPA with a big enterprise that is very risk averse and doesn't want you to use plain text information. So what do? You have to try to see how you can aggregate information, how you can anonymize information so that you can still get the learnings that you need without necessarily transferring that party's sensitive personal information to a different environment, which might put you in breach. So I do think it's very necessary for lawyers to be involved in the choosing and just understanding the constraints of certain pets.
Mm.
So just to go into different pets again, so we talked about federated learning, but there's also other techniques like secure multi-party computation, which allows for the shared computation without each party seeing the other's data set. And I think, there's a lot of pros and cons to each method, but for some methods like homomorphic encryption, which means encryption and processing, there are certain computations that might be too complex for it. So this method works best when you're dealing with linear regression, logistical regression, but the bandwidth and the overheads might become prohibited when you're trying to apply it to neural networks
Mm.
or decision trees. There are some other methods that might be more appropriate to, for example, obfuscating privacy by injecting noise and synthetic data like differential privacy, but that also means that you lose that much accuracy depending on the privacy budget. So when you're working in a highly regulated sector where accuracy actually might be your priority, so for financial services, having accuracy of credit scores, accuracy of understanding fraud risk, that might be more important to you than having a low overhead for implementing these techniques. So I do think, this whole topic, privacy enhancing ML, is a really good place for lawyers to get involved in technology and design of products to try to embed these core principles of data rights and just democratic values for privacy into actual corporations and how they operate. So I think that's a really interesting and emerging domain.
Everyone is looking for a way to leverage all these data they've been collecting for a long time. And we have this new legal framework. And in the US, there's the algorithmic accountability framework. And then in Europe, we've got this privacy regulation, which is taking shape fast. How do you see it working? How do you see pets helping in different parts of the chain of custody until it gets to the final use?
Yeah, that is an excellent question. I think with the upcoming AI regulations, we're really seeing the strong connection between good data governance and good AI ethics. Because, a lot of information governance, it checks for lawful basis of the data, it checks for the accuracy of data, whether the data is representational, and that leads to a better and more robust AI system. And I think that pets can help several privacy objectives for AI and make it more ethical to deploy. And number one is the privacy in the training data. So, of course, you have to have a contract for a lawful basis and having appropriate governance to commingle data from multiple sources. You need to check if there's sensitive data that you need to manage with additional safeguards and whether you have a contract with people that defines the purposes of such processing. And privacy enhancing technologies, it helps actualize these commitments into the product lifecycle by, having the privacy layer on top of it. And then there's also the privacy and model inference that you just mentioned. So, there are ways that someone can try to extract or invert sensitive information from the model output. If it contains proxy information or something that is linkable or interpreted back to the individual. And the privacy enhancing technologies, it since it is in such a distributed and decentralized way, firstly, it doesn't really centralize the security risk of having everything in one place because in a lot of these methods, different parties are computing in their own environment and then coming together for an output. Also, with the secure aggregation layer on top of certain PETS methods, there are ways that you can have extra security against people that are trying to unveil model parameters with extraction attacks and unveiling what type of query goes into the output. So there's that. And then I think for thirdly, having privacy enhancing technologies, it helps with getting more data for model validation metrics. So one problem is when it comes to enterprises adopting fairness metrics, you actually need data to compare your output against to see that it's not deviating or having an unusual statistical deviance based on a demographic group. But getting this information is sensitive, and a lot of people just don't want to have sensitive information in their systems because it's the risk and a liability. So, because privacy enhancing technologies allows you to tap into data sources without getting them out of their environment, without having them in your environment in order to analyze their results, that's something that's going to be a powerful tool for advancing fairness metrics in AI as well.
Sunny, thanks for that. So that's a good summary. We've got all of these DPOs listening to us and warning at the conferences, and everyone is hearing about privacy enhancing technologies. Can they leverage privacy enhancing technologies when they are not already part of the bundle of the AI that is, being supplied to them? Is there anything they can do to leverage them, or do you think they're only really available to the companies that develop the models?
So I think that privacy professionals should always ask questions to their model risk management team because they usually keep the inventory of the different models that have been deployed in the company and some of the performance metrics that they're putting them against and how they monitor it. Understanding this inventory and maybe sometimes working together with them to form a gap assessment on different auditing requirements for models that are deployed in the company, it's a great way to engage in that conversation and understand like what are some of the third party risks around AI systems that you're acquiring. Where is it being deployed? Is it on premise? Is it in a cloud? Do you have to do a transfer risk assessment? So there's a lot of different ways that privacy professionals can engage in this, and I think that they absolutely should. So just keeping that conversation alive between privacy legal and people who are actually in charge of overseeing the models is critical. And then I think number two is just understanding the regulatory implications of why pets would need to be used in a company. Because as we already mentioned, pets is a significant investment. Not every company has the bandwidth to overhaul their legacy systems to experiment
Exactly.
with it. So it is definitely, we're still getting to the part of democratizing privacy enhancing technologies, but we're still far ways away from it because proof of concept with these vendors, it can be quite expensive. And it's hard to get corporate buy-in to replace your current systems, which, in people's eyes, it works perfectly fine because it's business as usual. And then replacing it with a privacy enhanced system, which honestly might actually have overhead. So it's good from a legal and regulatory perspective sometimes, but in the business leader's mind, they might think, why would I want something that makes the program 10 times slower for the same result? And
That story sounds familiar.
yeah, so to justify that, I think, privacy professionals need to be clear about why we want this because number one, it's not just about having contractual rights to use data. Once we have plain text data, there's a burden of data governance, and that's costly as well. And having privacy enhancing technologies might have a lot of upfront costs, but it does reduce the data governance by having, aggregated and anonymized information instead of just raw text information floating around. It also
Exactly.
helps alleviate some issues around, when you're computing with multiple parties, you might not trust every single party. You might think there is a possibility that me as a data owner giving my data to a model owner to use for their model, they might try to keep it. They might not be transparent about it. So having privacy enhancing technologies acts as a bulwark against those types of situations, because you're saying you can compute on my valuable information, you can't see it, you can't have it in your systems. And that prevents potential harms that could happen for unauthorized use or adversarial attacks.
Which is also very good from a competition point of view and even IP. Sunny, thank you very much. This was really good. Thank you.
Thank you. Thank you so much for having me here. I'm glad that I was able to delve into a very dense topic here.
You
And
sure were.
hopefully this, just spurs some conversations in companies
I,
around what rights are and how you can use it.
I'm sure it will. Okay, that's all for today. And you will find some episode notes and links to our social channels on mastersofprivacy.com. Thank you for listening.